All right, I think we're ready for our next case, which is Karen Zimmerman and Albert Zimmerman versus Robert Horstmann and Gail Horstmann. All right, counsel, whenever you're ready.
Thank you, Your Honors. May it please the Court. Michael Lesage for the Zimmermans, with me Senior Counsel Robert Telford Jr. We are here today on behalf of appellants appealing the entry of a summary judgment at the trial court. Essentially, this case boils down to whether a hidden or concealed step could constitute a dangerous condition giving rise to a separate duty to warn. There's a very good picture, which I improvidently forgot to ask permission to bring to the court, in the record at record 389 that shows the condition of the step that Ms. Zimmerman followed.
What do we do with the fact that, I mean, the allegation is that the change in elevation is hidden by whatever, and I know it's contested as to what one of two things was on the step, but you look at the very good picture and you can clearly see the change of elevation. I mean, there's no hidden change of elevation. The rug doesn't appear to mask the fact that there's an elevation change in any way whatsoever.
It just happens to droop over it.
And there are three pictures in the record, two looking up at the steps, one looking down from the laundry room into the garage area. I would point this court's attention to page 21 of the hearing transcript, where the trial judge, looking at the pictures, twice indicated that she was unsure whether that was one step or two. So based on that alone, I believe there's a factual question as to whether there was one step or two steps as indicated by the pictures, and based on that alone, we believe the question should have been resolved by a jury.
That's pretty much the whole argument, isn't it?
Well, those are some of the high points. So we got to those
I don't
early.
need to sweep it under the rug or anything. Sorry.
But we've cited a number of cases, and in our initial brief.
Let me ask you about, I mean, one of the grounds for the defendant's request for summary judgment was an argument that you have to pyramid inferences to get to the position that you want to get to. In other words, that it was negligence that caused, so the causation element of the negligence claim. And that, to me, seems to be true, although that wasn't the ground that the trial judge granted summary judgment on. I mean, the testimony of your client was that she wasn't looking, she has no idea basically what happened because she wasn't looking down. So we have to, I guess, infer that it was a change in elevation that caused her to fall when we don't know that, and we have to infer that it's because there was a rug there and she wouldn't have otherwise seen it, and we don't know. I mean, it seems like there are a lot of inferences that you have to pyramid together in order to support your theory on a causation basis. You want to address that argument?
Yes, she did state essentially that in her deposition. Later, on page 70 of her deposition, as indicated in the reply brief, she essentially said that she did not see the step because it was obscured or hidden by the rug, which caused her to fall. Mr. Orr, her friend who appeared several minutes after.
I thought her testimony was that when she was laying on the ground, she looked up and decided that must have been what happened.
I think it's close to that, Your Honor, and I would bring the Court's attention to the Holland case that was cited, as well as the Aguiar case, which I believe is 5th District. That issue was
The
addressed.
Holland case was the tile case, right? The elevated tile case?
Yes, where it was, she didn't know.
Isn't that case different in that in that case, there were a lot of witnesses who said that that tile was raised, it was the only thing that could have caused her to fall, and that other people had tripped on that and the owner had notice of that unsafe condition. I mean, that's sort of very different from the facts we have here, where you have one person looking at what the pictures show, an open and obvious condition, a change of elevation, and she doesn't know what caused. I mean, that seemed very different from the Holland case.
And to the extent I believe Your Honor is correct that it is different from the Holland case and perhaps closer to the Aguiar case, where, as I recall, she was stepping down off a curb, there was some raised caulking, and she could have fallen off of the raised caulking, but likewise did not know what she fell on exactly. One of the Pensacola cases with the racetrack has very similar facts on an expansion joint. So I would certainly argue that though the trial court's ruling was not based on that argument, that because someone falls, there's no requirement that they be able to identify the cause of their fall. Otherwise, it would almost completely wipe out any case where someone fell, because I think that would require testimony that, well, I saw this big crack on the ground and then I proceeded to step in it and that was the cause of my fall.
Yeah, but your client didn't even know where her foot was when it twisted.
I believe she said it was on the rug.
Let's see. I wasn't looking forward, I wasn't looking down, therefore I couldn't tell you where my left foot was.
She didn't know, no. She said she didn't know.
So it'll be right around page 70 in that transcript. But that is essentially, as the court's well aware, she was walking from the kitchen through the laundry room into the garage, across that step that our position is it was hidden by the rug, she did not see it. As she stepped down, she fell, landed on the ground, at which point she saw the carpet overhanging the lip of the step, and according to Mr. Orr, who appeared several minutes later, the rug appeared to have moved. So taking the evidence in the light most favorable to the non-moving party, as a trial court and this court must, we would certainly argue.
Is it different in this case because one of the possible or probable causes of the fall was a change in elevation, and there's a whole line of cases that says a change of elevation alone in a residential, in a house, you can't sue for that because it's generally just an open and obvious condition. People got to know that there are all sorts of elevation. I mean, that's what the case law says.
Your Honor.
So you have one potential cause for the fall that means no liability. And then we have other potential causes of the fall. But I mean, doesn't that create a pyramiding of inferences? In other words, you got to infer that the cause was something other than what the law says there's no liability for, and you got to make several inferences to get there. I mean, that's where I'm having the problem, I guess.
Well, I think Your Honor is absolutely correct in terms of the case law that the long-established law of the state is that a change in elevation in a residential home is not a dangerous condition, hence there's no duty to warn. So obviously, if this was a step alone that she fell over, no, Your Honor is correct, there would be no liability. We would argue that it is the unusual placement of the rug on the step that operated to conceal or hide the step, which created...
How do you know that when she, by her own testimony, wasn't looking down and doesn't know where or how she fell, without drawing a lot of inferences?
Well, I think that essentially would be the inference that would be drawn, that she didn't see the step because she fell at that location. And I think that it's a very plausible inference that the reason she didn't see the step was the fact it was obscured by...
That's two inferences.
That's enough, yes.
So, but...
Let me understand. Is it your position then that even though I'm hearing you at least say there are two inferences, so that could be considered beginning at least of pyramiding, are you saying that this court should allow this case still to go back to be the summary judgment to be reversed and go back so a jury can make a decision, but practically speaking, what would probably happen is there would be a directed verdict, because at some point, these inferences, this pyramid of inferences, exist. I mean, they do exist. So why should this court just go ahead and affirm it? Because we know, and you're aware, that there has to be certain inferences in order for the causation issue to be addressed.
At the summary judgment stage, the inferences obviously are taken in the light most favorable to the non-moving party. And I think that there is, are there two potential inferences? Obviously there are.
And perhaps more, yes?
Sorry.
And perhaps more than two, but go ahead.
Well, I think there's a possible inference that the cause of the fall was simply that Mrs. Zimmerman did not see the step. And I think that would get us, get her to a jury on the question of whether the unusual placement of the rug constituted a dangerous condition. So that would essentially be our argument. One of the interesting cases, it's not on a step, but it's a Fiore case, which indicates that the presence of a rug or little area rug on a level floor itself could constitute a dangerous condition.
I have to admit, I don't really understand that case.
So, well, that obviously if that's a jury question on a level floor, I think it would strain logic to hold that a rug on a level floor could constitute a dangerous condition, but by somehow adding a step to that rug, the step would make the rug safer. So I think in this case, like in that one, there would be a jury question present. So a number of the cases cited by appellants indicate the large number of objects that have been found in Florida to be potentially dangerous conditions.
So it's your position that as a matter of law, every rug in every home and every business in Florida is a dangerous condition?
No, Your Honor.
Why not? I mean,
I believe it's more fact specific.
What other fact did you have in Fiore? There's a rug on the floor. I mean, there could have been other facts in that case of the rug. It says it's terrazzo. That can be slippery. Maybe I don't know what all the facts were, but given the facts and the opinion, is it your position that a rug is a dangerous condition?
I believe
Or creates a jury question. I mean, you get to the jury if there's a rug. Somebody slips near on at a rug.
It's our position, Your Honor, that the unusual placement, and that's recognized in the Rice case, or at least it's inferred in the Rice case, that the unusual placement of an object could create a dangerous condition. Mrs. Zimmerman's testimony in this case was that she was completely unfamiliar with anyone putting a rug on a step so the step couldn't be seen, which was her testimony in this case. So we would argue that along with the picture and the court's uncertainty in terms of whether there's one step or two steps would show there's a jury question as to whether the placement of the rug on that type of rug on the step was unusual. If it was a bright red rug that said step, that may not be a question. But there is a case, and I'll get to that on rebuttal if Your Honors will permit me, where someone with the name and the site, someone in a store hit their foot on a raised platform that was several inches high, where the side of the platform was painted.
I don't remember a case like that being cited. Was that in your brief?
It would have been in one of the briefs, and I'll just have to look at my quick summaries. But essentially, someone hit their foot on a slightly raised platform, the side of which was painted one color, the top of which was painted another color in a store. So the cases in Florida indicate only the great variety of objects that could potentially be dangerous conditions, which should be addressed by the jury, from parking lot bumpers to mats in a number of cases, including the Fiore case, to obviously unusual design of tables and chairs concealing changes in elevations, the Chattahoochee coating on the steps in the, I believe that's the is that Kupperman case? The Glansberg case, the unusual coating on the steps. We would argue that the facts of this case are very similar to that one, in that the coating on the steps in the Glansberg case made them difficult to see. Likewise, the picture on file in this case made the step difficult to see. So we would argue we're very close to those facts, and that essentially this was a jury question that should be addressed by a jury. So essentially, taking the evidence in the light most favorable to the non-moving party, we believe there is certainly a jury question present as to whether the rug concealed or hid the step, whether the placement was unusual. There was testimony that the rug was overhanging the lip of the step and that it appeared to have moved after she fell. And as I said, Ms. Zimmerman was not familiar with anyone else so obscuring a step. So we would certainly argue that this case is distinguishable from the Hogue, Schoen, and Casby cases recognized by the court, and ask this court to reverse and remand to be tried by a jury. So if Your Honors will permit me, I'd like to reserve my remaining time for rebuttal.
All right. You have
Thank you.
4 minutes and 48 seconds.
Good morning. May it please the court. My name is Jamie Bellotti Moses from Fisher Rushmore in Orlando. At counsel's table with me is our summer associate, Eric Elms from the University of Florida. I would like to clarify a few issues that were raised by the court during Mr. Lesage's introduction. As a preliminary matter, at page 21 of the hearing transcript, the court did say, I can't tell if it's 1 or 2 steps. And Mr. King responded and said, I believe that Mr. Tefler has a better picture. A better picture was then presented to the court, and she said, so there's 2 steps. Once she saw a better picture, she could see the steps that we're talking about. There was a suggestion that even the court couldn't see the steps, and I believe once the court was provided with a better picture, she could see the condition of which Ms. Zimmerman is complaining. Second of all, in Ms. Zimmerman's deposition, there has been a suggestion that her testimony is she didn't know what made her fall. She stated in her deposition, the change in elevation is what made her fall. It is not about the mat or the type of mat. That's why we conceded, call it a scatter rug, call it a welcome mat, whatever you call it. The accusation in this case is that it was the change in elevation and only the change in elevation that caused her to fall. Therefore, the issue as to what type of rug it was completely irrelevant. Her position in the case, both in the complaint, in her answers to interrogatories, and in her deposition, was that it was the change in elevation. As Judge Lawson pointed out, there is a plethora of case law that specifically holds that a change in elevation is not a dangerous condition as a matter of law. I will agree with counsel that there are circumstances that the courts have found make this general rule not the general rule, and that is traditionally...
Just a second. You're saying that it was a change in elevation only. Isn't that in and of itself a factual question?
Well, no, ma'am, a factual question. It's definitely not, it's not a disputed factual question, because she was asked, did the mat move? No. Did you know, she doesn't testify her heel was caught on the mat. The allegation is because the mat was there, she couldn't tell there was a change in elevation, and the dangerous condition is the change in elevation. There is a case that has been cited by opposing counsel where they put a mat over broken tile and the person fell. That is different than this case. In other cases, for example, the Fiore case, the distinguishing condition in that case was, and I agree with Judge Lawson, I do not understand that case, but it's out of the Fifth, so it needs to be addressed. The allegation in that case was that the rug itself caused the fall. The rug itself, that it was a completely flat room, there was the terrazzo tile, that maybe because terrazzo is slippery, the rug did not stay down, and therefore she fell on the rug. The allegations through the complaint, answers to interrogatories, and deposition is it was the change in elevation that I never appreciated.
In this case?
In this case,
of
yes, ma'am.
So what you're saying to the court then is that even though it would be a factual issue, it's undisputed facts that it was a change in elevation only?
That's her contention. I mean, of course, my clients aren't going to say, you're right, our step made you fall. But the allegations against my clients are that it was the change in elevation. Now, ironically, and most important in this case, because in many of the other cases, for example, the case against Walt Disney World, which I believe is the Aguilar case.
It is.
Excuse me?
That's right.
There was allegations and proof of knowledge by Disney that there was a problem with the caulking. Okay? And in our case, Ms. Zimmerman admits stepping up onto the rug and into the house. Now, had there been an allegation that Ms. Zimmerman's stride was so long that she never even touched the rug to get into the house, we might have a different factual situation here. But she says in deposition and admits that, yes, I stepped on the rug going in. So she is aware of it being there. I can't explain how you cannot appreciate the step when you step on into the rug and then you step into the threshold. There was an acknowledgement in her deposition by Ms. Zimmerman that she then had to step into the house. So this is a common pathway that she's gone through, and that is sort of like the pilot case, which I believe it's either Hogue or Schoen, where the court said basically you followed the worker through the house, you basically had a pilot guiding you, and when he stepped down, you saw that. Ms. Zimmerman, for lack of a better term, was her own pilot. She's walked over this path before. It wasn't until she fell and looked back and then suddenly says, oh, it must...
Why wouldn't, I mean, that argument seems like almost a comparative fault argument. Why wouldn't that be an issue of comparative fault? Whether she was negligent because she didn't pay attention the first time she went up and...
To get to comparative fault, you have to have a dangerous condition, which would create a duty on my client's part.
Right.
I feel, in my opinion, under the case law, which the court has recognized, we don't even have a dangerous condition. So we don't even get to comparative fault.
But you're talking about something that sounds like comparable.
Oh, just to bring it up, to distinguish it from all the other cases that have been cited extensively in Appellee's brief. The distinguishing factor in all of those cases is either uncommon construction or the way it's maintained.
I mean, the whole case boils down to the first sentence that opposing counsel said. Does it create a dangerous condition? I mean, that's the entire thing, isn't it?
Correct. And
so either it does or it doesn't, and the only evidence of it appears to be her testimony that she didn't see anything, and the pictures. Right?
Correct.
What else is out there?
Well, I agree with that. But I think what makes it important is the fact that she's already gone over this and acknowledged. It is not as if Ms. Zimmerman walked out of the house, said, I couldn't see the step and I fell on it. I do think that's important because it is a change in elevation that she has already appreciated once to get into the house.
But I don't know that that necessarily justifies a summary judgment. I think that she was not looking down. She was looking forward, not looking down, and didn't know where she fell is frankly much more compelling.
That she didn't know where she fell? I believe I did read you, I did just hear you mention she said she didn't know where her left foot was.
Therefore, I couldn't tell you where my left foot was is a direct quote.
Mm-hmm. On the mat, but she acknowledges it was on the mat, which is on the step. That's the way I read the deposition testimony. Granted, I wasn't there, but she doesn't dispute stepping down onto the mat.
Right.
And I think what that question was about was where on the mat was it, because there was, as the court is well aware, there's a dispute as to what type of mat was on the step. And for purposes of summary judgment, we conceded, call it whatever you want, it's a change in elevation and you knew about the change in elevation. But I believe that question...
What Judge Monica's saying is we understand the argument. Yeah. It's pretty simple and straightforward.
Okay, I will take a cue from the court. Unless there are further questions, I will sit down. And we would ask that you affirm the judgment below.
Thank you.
Thank you.
Hey,
Counsel, you got 4 minutes and 46 seconds.
Thank you, Your Honor. Just briefly, the case I brought to the court's attention but couldn't give the cite for was Pensacola Restaurant v. Davidson. That was with a platform raised several inches with different colors. We would also bring the court's attention to the Harrigal case with the clothing rack. If I could, I'd like to read.
Counsel, these photographs that are in the record, one appears to have a welcome. One photograph is a rug with a welcome scroll across it. The other is a rug with palm trees on it.
Yes, Your Honor.
Tell me about, what do we know about the rug that was there?
There's a factual dispute as to what type of rug was present. Mr. Orr and the Zimmermans maintain it's similar to the one at 389 that hides or obscures the step.
Is that the palm tree rug?
Yes, Your Honor. The Horstmans maintain it was, in fact, not that rug, but a welcome mat, which would obviously create a totally different visual.
So the only way summary judgment could be granted is if the court considered your client's testimony that it was the palm tree rug that was the important one.
Yes, Your Honor. And going back to Ms. Zimmerman's deposition, page 73, I was off by several pages. Question. After you're on the floor and look back and see the 3-inch riser, what is your presumption as to why you fell? Answer. There was a rug covering a step that I couldn't see. Okay, and how did that cause you to fall? Answer. There was a change in elevation that could not be detected because it was covered by a rug. And then on page 74, you're saying the elevation between the garage floor and what's covered by the rug, this approximate 3-inch riser. Right, a change that I could not see. And then below that, but the rug isn't hanging over the lip, is it? Answer, yes. So certainly, we believe there's a question there. Miss, terrible names this morning, but Appali addressed the Hogue case with the pilot and the fact she traversed the steps going in and coming out. We would point this court's attention to the fact that case was decided in the 50s, which I believe is before Florida adopted the doctrine of comparative negligence. And we bring the court's attention to the Lomack v. Mowry case, where the cleaning woman fell over some wires where she, in an area she cleaned 100 times before, and the court nonetheless held that was a jury question as to whether it was a dangerous condition, and also giving rise to a separate duty to warn. So hence, I believe those issues go to comparative negligence. And then just going back to the hearing transcript on page 21, Appali, they had presented, I guess, 2 pictures to the court. The court, I can't tell if it's 1-step or 2-step. Several lines further down, Mr. Telfer, I have 2. I believe that refers to photographs. This is a mat. The defendant said it was on the step. That's in dispute. The court, so there's 2 steps, question mark. So even with all the pictures in the file, the court appeared unsure as to whether, looking at those photographs, there was in fact 1-step or 2-step.
Well, that's because the bottom part of it looks like it's ground or earth, but you can't really tell from the photographs. But the part where the rug is I mean, you know you can see the step there. And
that would be our contention, that essentially the placement of that rug on the step operated to hide what the exact change in elevation was, or the step itself, which created a jury question as to whether it was a dangerous condition, and hence whether there was also a separate duty to warn, though obviously the issues of comparative negligence will at that point come into play. So if the court has no further questions.
Thank you, Counselor.
Thank you.